Chapters 26 and 27 should also be considered as one chapter, as the content is linked. And here our theme is how to be a creditor, or how to be a secure creditor. As a creditor, you want to know that the debtor will pay you regardless of the debtor's word. You want to be secured, assured of payment. How can we then be a smart creditor? Look at slide 2 and note that we'll be reviewing consensual liens at the close of this lecture. But note that on slide 4, the tags mechanics lien and artisan lien are not rather clear at first, and it's best, I think, to group these two as non-possessory and possessory. In a non-possessory lien, the worker can't possess the kitchen he remodeled that he completed for the owner, yet he can file a claim or an interest for payment against it. However, in the possessory lien, the worker can keep possession of an item until the owner pays. Possession, then, is a way of claiming a right of payment against the property. That's a lien. Hence, that's why a car mechanic never gives back your car after she repairs it until she has been paid in full. So she can then sell it under the legal matter of an artisan's lien for the labor and parts that she expended. Garnishment is not a garnish, that's the parsley on your plate. I can garnishee a debtor's property that a third party holds, someone such as an employer who might owe wages to the debtor, or a bank who's holding the debtor's account. However, I must previously have gone to court and won a judgment against the debtor. I am then called a judgment creditor and can seek garnishment against the debtor to satisfy the judgment. So we garnishee, we don't garnish. Composition agreement, see slide 6, is where creditors join together to get their full money from the debtor, but in smaller installments over a longer period of time. If one takes his full share, all the creditors lose, for the debtor has no ability to pay all. So the debtor composes his creditors, a composition, who then agree to take less over a longer period of time. Note that we do not discuss in slide 7 mortgages at all in this course, but I included it. And if you have any question, please email me for further discussion. On slide 9, ABCs, or assignments for the benefit of creditors, are just like composition agreements, except that we add a trustee to the mix. The debtor assigns all assets and liabilities, instead of to the creditors, to the trustee, in name only, who then can manage these affairs much like a power of attorney would manage the attorney or the benefactor, the beneficiary. The creditors, as before, receive their full money, but in smaller installments over a longer period of time. So I have a quick question for thought. If you faced an assignment for the benefit of creditors, who would you recommend as a trustee? A bank, an accountant, a lawyer? Personally, I feel the trustee should be an individual who is very familiar with the industry of that debtor. Then that trustee has the knowledge and experience to help the debtor's business rise out of debt. So, for instance, if the debtor were involved in trucking, I would say hire a retired trucking president who can help manage the debt and get the debtor's business back on its feet. On slide 10, we see that a surety company can underwrite the potential losses of any party that may owe another damages. For instance, before we build our large mall, let's say, we hire a contractor and ask that his work be guaranteed. Should the contractor fail to build, as he should, we think breach of contract, the surety or third-party guarantee company would then pay us our damages rather than us trying to chase down the contractor. Nonetheless, the contractor would owe the surety any reimbursement under their contract. Our last slide, slide 16, we review how the law protects debtors from losing all their property. For example, in Washington, a debtor can claim a homestead exemption and remove his personal car from a creditor who attempts to seize it under a sheriff's sale or a writ of execution. However, in Washington, the debtor is permitted only the first $6,000 of that car's value. The remainder then goes to the creditor. So if the forced sale of the car sells at $10,000, the debtor keeps $6,000, and the creditor keeps $4,000 minus the costs of the sale. Claiming an exemption, however, is a once-in-a-lifetime matter.